Good morning friends. Do you remember our video published 3 years ago in which we discussed the Kerala High Court judgment on deduction of TDS on salaries paid to the religious personals? If not, first go through that video to get a background and complete understanding on this topic. As you all must be aware by now, there has been a long-standing debate in the charitable and religious sector regarding TDS deduction from the salaries of nuns and priests, especially those working in the educational and medical institutions. In the recent past, a Supreme Court order dated 7th November 2024 has now given a clear direction on this matter. I am Ashis Agarwal from Team NGOenabler, and today in my video I am going to discuss this important update which is highly relevant for religious organizations, missionary institutions and NGOs employing religious personnel. There are three major points to take away from this decision of the Honorable Supreme Court. First and the most crucial point, the special leave petitions filed by various religious institutions were heard by the Honorable Supreme Court challenging the High Court's view that TDS must be deducted from salaries paid to the nuns and priests, even if that salary is fully surrendered to their religious congregation. The Supreme Court dismissed the special leave petitions, meaning thereby the court was not inclined to interfere in the matter and has effectively upheld the view that TDS is applicable. This judgment applies to a wide range of similar appeals filed by the Catholic institutions and diocesan bodies across the country. The second point relates to the background of the dispute. These cases arose because in practice, many educational and charitable institutions did not deduct TDS from the salaries of nuns and priests. The reason being, such individuals voluntarily surrendered their salaries to the church or religious order and did not derive any personal benefit from the income. However, the Income Tax Department took the stand that salary income is taxable in the hands of the recipient irrespective of whether it is voluntarily handed over to someone else. Accordingly, they issued notices and demands for non-deduction of TDS. This triggered a large number of litigations which eventually reached the Supreme Court, and the stand of the Income Tax Department in such cases was upheld by the Apex Court. The third and the final takeaway is its implication for the NGO sector. This ruling now settles the matter. TDS deduction under Section 192 of the Income Tax Act is mandatory in the case of the religious persons working as employees. The surrender of salary to a religious institution does not change its taxability. Hence, the schools, colleges, hospitals, trusts and societies managed by the religious orders will now have to ensure that TDS is properly deducted and deposited, even if the salary is not retained by the individual and is directly transferred to its parent organization. So this was all about the latest Supreme Court judgment relevant in the context of religious institutions and charitable organizations. For more such updates, keep tuned to our channel. Don't forget to subscribe it and put your notifications on. And for any clarification, feel free to reach out us through email or comment below. You can also follow us on Facebook, Twitter, Instagram and LinkedIn. Thank you.